Good afternoon, everyone. I welcome you to today's broadcast, the DOL Fiduciary Rule. This may well be one of the most important webinars you attend this year. Please note, due to today's topic, we'll probably go 45 minutes to an hour. We will not open the phone lines as is normal on a Great Plains webinar, so please use the question dialog box. If you've got any questions, I'll try to feed those to our presenter, depending on the time available. If we don't get to your question, we will follow up with you, or you can contact your Great Plains Annuity Marketing Consultant at 1-800-710-1115. Our presenter today is Paul Garofoli, Marketing Vice President at National Western Life. Paul has been very active in monitoring and fighting this regulation and has the latest updates for us, and I believe Paul is one of the most knowledgeable regarding the current status of this rule and how it may affect all our future business models. Here's what producers should prepare for. We've got a lot to cover today. There's a lot yet to come, but I think Paul's going to be very helpful to you in giving you the current lay of the land. Whether you've been following this proposed ruling for the past year or just became aware, Paul is going to present that information that we all need to be staying on track of and following. Paul, please bring us up to speed on what this rule could mean to producers and where the process is right now.
Thank you, Rob Edwards, and thank you, Great Plains. Hey, and thank you for being right on the vanguard of getting informed on this issue. You know, there's been a lot of writing, there's been a lot of pontificating, and I'm going to do a little bit of both on this, or a lot of presenting on this. You know, I feel like I'm on top of this. I just got back from Washington, D.C. with the NAFA organization, National Association for Fixed Annuities, lobbying directly to Congress on this matter. You'll also come to learn that National Western Life, my company, based here in beautiful Austin, Texas, and so pleased to be working with Rob and his team at Great Plains, has been at the forefront of this issue. But before we get started, just a couple of, you know, additional pieces of information that I think might be helpful for you. You know, a lot of people think of National Western Life as an annuity company, and indeed we do. You know, we're in and around $1 billion of annuities each and every year, and that's why, you know, we're all in and fully committed to informing you of the DOL regulation, the good, bad, and the ugly, and fighting it big time, with money, with effort, with sweat and tears. So keep that in mind, that even though you may know us as annuities, we also do life insurance. So you came for annuities, stay for life with National Western Life, and of course with Great Plains Annuity and Life, Life and Annuity, they are equally adept at both product lines as well. So you can access us there in that way. Just give me a second here. Just a little bit of a frozen screen, so we're just seconds away. And so now, to the topic at hand. And by the way, this information is current as of Tuesday, June 14th. So the DOL rules were released, and I want to emphasize a few things. This will have an impact on your business. If you have dealt with qualified funds in any form or fashion in your practice, thought about it, it's going to affect what you do. But that's the first point of emphasis, ladies and gentlemen. The regulation applies to qualified funds. That means 401ks, IRAs, and yes, Roth IRAs. I have had and done this presentation. People say Roth IRAs are not qualified accounts. They are. Even though they are going to be tax-free accounts, they are and meet the definition of a qualified account and therefore come under the jurisdiction of this regulation. So that affects rollovers, new accounts, any type of service, advice, recommendations that you make with qualified money, qualified funds, typically 401ks and IRAs. New standards of care apply. Now, a lot of people say, well, wait a minute, how does the DOL get involved in this, and why are we where we are? Well, the Department of Labor has jurisdiction over qualified accounts by way of the 1974 ERISA Act, E-R-I-S-A. That's the Employee Retirement Income Security Act, and really the legislation that saw and permitted the 401k. So the Department of Labor has taken the oversight of 401ks and extended that to all qualified funds, IRAs, even if they're standalone, and certainly anything funding from 401k. Now, you may have your own political persuasions. I have mine. I'll try to keep those to a minimum, and let's just deal with the reality on why we are where we're at. And, I don't see a lot of conspiracies. I see unintended consequences of perhaps well-intentioned acts. So let's try to put the shoe on the other foot. Let's try to look at it from the government's perspective, from the Department of Labor's perspective, and maybe from your perspective as well. You recognize this. Gosh, in the span, most of us who have been in this business, in the span of our careers, I'm pleased to say I've been in the business 34 years, we have seen a complete reversal of what the retirement picture was like when I first entered the business to where we are today. And you know this in your own practices. There are fewer pensions today. 30 years ago, 40 years ago, 80% of the American workers out there were covered by some defined benefit pension program. Now it's less than 20%. It's the complete reverse. So what that means is, by way of the 401k, the IRA, the Roth IRA, there is more do-it-yourself planning for retirement. And ultimately, what motivates the Department of Labor is the perception that conflicted advice, that is advice that could be influenced by compensation, commissions, incentives, maybe your own biases, could cost the American consumer billions of dollars. Now, there's an irony here that at the very time more and more people need good advice, need services, need counseling, need a catalyst, quite frankly, and I think that's where we in our profession as financial service professionals, advisors, hey, insurance agents, one of the things that we do well is motivate people, identify the problem, and then propose solutions to the problem. So the irony that I look at first is that at the very time more and more people need good services, good counseling, now there are regulations and oversight that's going to make that increasingly difficult to do. And in fact, when I was in D.C. talking to Congress people and senators, one of the things I pointed out is that this regulation is going to hurt the average consumer. It is going to make it more difficult for that consumer to get personal, local advice. And you'll see why in a second. But this is the perspective that they have, a concern overall that the average American worker is not prepared for retirement. Gosh, I think it's up to 50% of the working population today has nothing saved for retirement. And of those that have saved for retirement, the average retirement account is $50,000. So we see that there's a crisis here. Now, this is the wrong idea at the wrong time. But what was the objective of the Department of Labor? And what they were looking to achieve is harmony. Now, I'm not going to do my The Voice or America's Got Talent because I have none in this regard. So I'm not going to start singing at you. But they're looking at consistency and harmony among the many ways that the American consumer can get advice in product and service recommendations, solutions for funding their retirement. So they're looking at harmony regardless of license. And you know that in the world of financial services, you can be insurance-only licensed, you can be securities licensed, you can be mutual fund licensed, you can be an investment advisor representative, you can be a fee-only planner. There's a variety of licenses and authorizations in terms of what you can do and what you can recommend for client funds. Again, emphasis, qualified funds only are affected by this regulation. And so the Department of Labor was looking for consistency and harmony, ultimately providing and operating in the client's best interest. Now I'm going to pause here for a second because many of you on this call are going to say, Paul, Rob, I always operate in the client's best interest. That's been my mantra. That's what motivates me each and every day. And I applaud you. That's me clapping right there. But the philosophy of looking out for the client's best interest and the legal definition and the documentation of that are two different things. So understand that. I applaud you. Everybody, just about everybody that I deal with here at National Western Life, all the great people, the thousands of agents that choose to represent my company and our products when they fit, when they're right, I believe that they're looking out for their clients in the best way they can. But that does not necessarily mean that they're in compliance, in particular, with this regulation, and you'll learn why in a little bit. Now, here's the good news. Congratulations. When it comes to qualified funds, you are now a fiduciary. That's actually a pretty good thing. You didn't have to take a test. You know, there's not going to be a stage to walk across. You won't get a diploma. But now, with regards to working with qualified funds, 401ks, IRAs, Roth IRAs, SEPs, Simplified Employee Pension Plans, any of these types of accounts, you now have to act as a fiduciary. So that, in my view, puts you on even footing with other types of financial services professionals. So, you know, there's some good news here, but here's the dark side of the cloud. And by the way, I tend to be an optimist on these things. And, you know, I always look for the upside in anything. So the glass is always half full when it comes to this, but there are going to be significant challenges for the average producer. But this may be one element that you are now recognized, at least by way of the Department of Labor, in terms of acting as a fiduciary. Now, what exactly does that mean? Well, the whole focus is impartial conduct standards, how you deal with a client's funds, the care and diligence that you work, and the advice and the product recommendations that you make. Well, the first standard of what a fiduciary is and what a fiduciary does is you give prudent, client-first advice. The client's interests are put above your own. Now, interestingly enough, there are different standards of advice. Prudent advice is actually fairly reasonable. It's what a typical person in a typical situation, knowing the facts of the client's needs, what that person would recommend. It's not necessarily the absolute best, but it's what a prudent person would recommend given the same set of circumstances and facts to know. Now, here's a challenge. Without regard to the advisor's financial interest, what you're going to learn about is that there are some things called exemptions, and we'll talk about that in a little bit. But there's an assumption. There's an assumption, the fact that you are getting paid in some form or fashion, and again, typically commissions on the insurance side, but fees, other types of compensation, that is perceived in and of itself as a conflict of interest. And so the Department of Labor recognized, well, people get products and services and advice in that way, so we're going to grant exemptions to that prohibition. In essence, getting paid, the assumption going in when you look at this regulation is a conflict of interest. How's that for having something to deal with? Now, what that means is since they recognize that, well, we're going to give you an exemption, Mr. Insurance Person, to continue making the recommendations, providing the valuable services that you provide, We're going to give you an exemption, but what you have to earn is reasonable compensation. Now, that's a question for the ages. How many angels dance on the head of a pin? That's a classic philosophy question, and you can have a variety of opinions. What is reasonable compensation? Well, Rob, I'm going to be bold. I'm going to declare it here on Tuesday, June 14th. Reasonable compensation is 10%. Why? Because I have a product, the Ultra Classic product, one of the popular ones that we offer here at National Western Life, that pays a 10% commission in those states where we're able to offer the product. You might say, Paul, come on now. All right, well, we understand that, but what are you talking about? Well, here's the justification that I will make. The gold standard in some people's view is a fee or a level commission. And typically people say, well, a 1% fee is reasonable. Well, when you consider that the average time a particular asset will stay in place is at least 10 years, and whether it's a CD or money market, people say, I have one-year CDs. How long have you been buying one-year CDs? Oh, 20 years. So people hold on to products for a long time. So let's assume for that fee-based compensation stream that it's a 1% fee, and I keep it for 10 years with that advisor or with that financial institution. What's 1% times 10? 10%. So that's how, if anybody asks, how I justify a 10% commission on our products. Now, other people might disagree. Regulators might disagree, and this is the concern that you need to have right now, and why you need, at the end of this call, in some form or fashion, to take action, because somebody else is going to define what reasonable compensation is. Is it a 1% level commission? Is it a 3% up front and 1% for 3 years? Is it 5%? This is the troubling element of this particular regulation. Reasonable compensation is not defined. And so you can draw your own conclusions. And let's face it, commissions have been declining. There is a war on compensation. Part of it is not of anyone's making. The interest rates are low. Carriers are forced to have compromised rates of return because there aren't any great ways to get yield, and the less that a company makes, the less that you're going to make. So there's been pressure, downward pressure already on commissions. Do you think there's going to be more pressure now with this regulation towards reasonable compensation? Then the final element of operating in the client's best interest, no misleading statements. And so I think relative to that aspect, I think just about all of us are there. We can't say no unlimited upside. We can say no cap. We can say no chance of losing money. There's some things we can say, but we can't say, hey, you can have this will perform as good as the stock market and you'll never lose money. Can't say that. That's misleading. Fixed index annuities don't work that way. So keep those things in mind. These are the elements that a fiduciary has to put in play when they're working, again, with the client's qualified accounts. So that being said, there's more. The requirement, the regulation, also eliminates any other incentives other than compensation that might influence the advisor. So, no iPads and Kindles and trips and dinners and conventions relative to this regulation as it applies to qualified funds. Not allowed, specifically prohibited. Then there's a compensation disclosure that's required. You have to reveal what you're getting paid for conducting that transaction. Again, now this is uniform, whether it's a variable annuity, whether it's a set of stocks, whether it is an annuity, a fixed index annuity. that is another requirement. And then, to cap it all off, a fiduciary contract for certain types of products. And this has been a big contention for companies like National Western Life and others, other of our carrier competitors, that there's, in addition to this, another contract that goes into place. Not only are you trying to operate in the client's best interest, there's a contract in place. You have to disclose compensation. So I think you can start to see how this will present a challenge to your business. Now, I'm going to put my Pollyanna. I'm going to be a little optimistic here. I believe in some form or fashion, each and every one of you on this call can still be in business in some form or fashion with this regulation. And I'll give you an example. You know, in my career, in my working career of 34 years, I've moved all over the country, from the Northeast to the Southeast to the Northwest, and now to the Southwest in Texas. I've bought and sold 8 houses every time I've moved. And every time over those 34 years, at closing, the paperwork gets thicker and thicker and thicker. And one of those things is a closing statement. And it shows me that the real estate agent's getting paid, that there's a title insurance company that's getting paid, there might be a closing attorney, there's other fees and registration, the home inspection. There's all kinds of fees disclosed to me. And if you add it all up relative to the purchase price, those fees add up maybe to 8 or 9% of the purchase price of the home that I bought at any particular point in time. Now I'm going to ask you, did I stop buying houses? Did I stop selling houses? Have people stopped buying and selling houses despite the complexity and the thickness of the paperwork? The answer is no. Is it a little bit more difficult? The answer is yes. And so one way or another, ideally, and don't get me wrong, I hope and pray that this regulation gets overturned, at minimum, extremely modified so that it can be workable. But even at its worst, as it is right now, and it's pretty bad, you and I and Great Plains and National Western Life, we're going to find a way to do business. So keep that in mind. But there's still things you can do maybe to make that easier for you. So ultimately, remember I told you there are exemptions. Remember the presumption that you're getting compensation in and of itself is a conflict of interest. But the Department of Labor recognized that, you know, that's a model. That's a way that a lot of people get good advice and great products. So we're going to preserve that, but with restrictions, with caveats. And what those are what we call, what you'll hear about is the BICE or the BIC, the best interest contract exemption, or the prohibited transaction exemption. Now just look at that. It's like, here's 2 things. Best interest, we're going to give you an exemption. A prohibited transaction, we're going to give you an exemption. So in and of itself, it's like, wow, man, that sounds pretty scary. This doesn't sound good for me, but I'm getting exempted. Well, here's where we are, and this is one of the big issues that came with the adoption of the DOL regulation. That is the placement of fixed index annuities, whether it's a 5-year contract, a 15-year contract, anything in between, as a best interest contract exemption. What that requires is a fiduciary contract, that you have a contract in place with the consumer outlining rights and obligations as a fiduciary. And that's a big challenge. Why? Because remember, most of you on this call, if you're working with Great Plains, you are independent. You know, you have no obligation to do one piece of business with me. You can choose a variety of companies, the ones that make sense at the time for your client. So how do I oversee as an insurance company what you're doing? It's hard to do. I'm not with you every day. You don't report to me. So that's the challenge, is how do we preserve the great work that the independent advisor field force has done for the American consumer with this type of regulation? Because obviously with this is significant liability. Now there's a less stringent, but still, still an issue. There's a prohibited transaction exemption. And where that lies is that fixed annuities, fixed rate annuities, fall under the prohibited transaction exemption. You'll still have to disclose your compensation, but there's no fiduciary contract in play. So ultimately, what this means, and I've had this reviewed by experts in our industry, there's basically 3 standards of care when this regulation goes into place, and we got some time, by the way, not that much, but we have some time. When this regulation goes into place, there's basically 3 standards of care or 3 standards of behavior in terms of how you conduct your business with the American consumer. So let's start with, I'm going to go to the far right, and let's go to non-qualified funds. For non-qualified funds, remember this regulation applies only to qualified funds. So for non-qualified funds, the standard of care is suitability. Is the product suitable? Doesn't have to be the best. Doesn't have to be any different than what's out there. As long as it's suitable, does it meet the needs in terms of safety, security, growth, whatever the client's primary needs are, is the product suitable? Do you have to have a fiduciary contract? No. Do you have to earn reasonable compensation? No. And do you have a commission disclosure? No. So for non-qualified funds, basically, your standard of care, the way that you conduct your business will be the same. It is unaffected by the Department of Labor regulation. Now, some will say, hey, look it, if you're going to start acting in a certain way relative to qualified funds, how long is it going to be before the same restrictions or requirements are going to apply to non-qualified funds? And I think that's a great question. Let's move from right to left, the middle column. For qualified, now we're in the qualified sector, IRAs, 401ks, other types of qualified plans. For qualified fixed annuities, fixed rate annuities, the standard of care is best interest. There is no fiduciary contract, however, that needs to be put in play. You have to earn reasonable comp, and you have to disclose that compensation. Then finally, for variable annuities and fixed index annuities, one of the greatest protectors, one of the greatest resources for preserving and growing clients' funds for retirement safely and with certainty, the fixed index annuity, a fiduciary contract has to be in place at time of sale. Reasonable comp is to be earned, and you have to have a fiduciary contract in play. So you see there's a whole spectrum of how you have to conduct yourself. The level and layers of disclosure here are what's there. Now, I said you had some time. Right now, in terms of the regulation itself, you have until April of 2017 to conduct yourself as a fiduciary. So as of April of 2017, that's really when you graduate to fiduciary school or from fiduciary school. And you will have to disclose the conflicts that you have by way of the reasonable compensation disclosure. And then January 2018 will be full implementation of this regulation. So by that time's happening. Now, people say, all right, okay, best interest, I get it. What's the big deal? Well, it's the Monday morning quarterback syndrome, or it's the backseat driver. And in the case of the visual here I have you, who's in the back seat? It's Washington, D.C., it's the government. The Monday morning quarterback, man, if I would have called that off-tackle play in that situation, all that. And the big fear for those of us as carriers, distributors, and advisors is that the Department of Labor specifically is allowing and promoting private action as a remedy for any violations of the fiduciary standard. What does private action mean? It means lawsuits. It means lawyers. And anytime we get the threat of litigation, insurance companies as an institution are naturally conservative, and it's like, oh, do we want to deal with that? So this whole concern about how it's enforced, how do you determine, who's going to determine that you operated as a fiduciary? Why did you give this advice? The Monday morning quarterbacking is extremely an issue at hand. So what's to be determined? Now, here's the big thing. As is, if nothing changes, if there's no court that overrules this regulation, if there's no adjustment by the Department of Labor, what has to be determined? Do you have your compensation disclosure document drafted? Do you have your fiduciary contract? Do you have a financial institution that has agreed to oversee your practices relative to how you conduct business with people's qualified funds? So disclosures, procedures, fiduciary contract, none of these exist. Somebody has to come up with them. How about defining reasonable compensation? What is it? What do you think it is? I declared it right at the offset of our presentation, 10%. Many others disagree. Some people think I'm nuts, including the lovely Mrs. Garofoli. But on this, I'm adamant. However, how about alternative commission schedules? All right, well, maybe we need to mirror or mimic what is determined to be acceptable compensation structures, a fee-based type of thing. How about an impact on product design and availability? Will we have certain products that are focused on qualified funds and yet other products that may be focused on non-qualified funds based on the degree of standard of care in the fiduciary best interest standard? How about conflicts with state regulation? Traditionally, insurance products are the purview of the various states that we all reside in. They are primary relative to regulation. Now, here's federal regulation that overrules and may come into conflict with state regulation. How about the practicality of carrier oversight? I touched upon it earlier. You're operating independently. Each and every one of you has your own unique way of doing business. Are you doing seminars? Are you on the radio? Are you doing mailers? Is it all referral? Do you have a source at a major employer in your town where you work on 401k rollovers? Each and every one of you do business differently. We don't provide you with the script. We don't provide you with the sales talk. You present these products in the best way you can at the right time in the right way for your clients, but we're not overseeing that. And then finally, the role of Rob and his team. How do they integrate into this new regime in terms of determining and enforcing and monitoring the fiduciary standards? So there's a lot to be said. Now, where are we now? This is hot off the presses. Updated this presentation today. Court action is already underway. And there are a variety of players. Up to today, there's actually 5 separate suits that have been filed by different business organizations, industry organizations. We'll talk about those in a little bit. And they make many claims. Some suits filed are based on some assumptions, some on others. So 5 suits filed. 3 are in Texas. 1 is in the District of Columbia, and 1 is in the great state, Rob, of Kansas. But what are the claims? What are the arguments that the suits make? A lack of authority of the DOL to regulate this form of insurance business, that the regulations are arbitrary, disruptive, expensive. Could you imagine we have to draw up documents and procedures and policies, maybe change product, maybe change compensation, the computer cost. One of the things that's a mandate of the Washington bureaucrats, the different executive agencies, is they have to consider the impact of cost on any of the regulations that are proposed. And I could tell you, they paid little or no attention to that requirement and woefully underestimated the cost to do that. There's even issues of free speech in terms of what you can talk to people about, what you can recommend, and expressing your opinion. If you're regulated, what will you recommend? What will you say? And due process, that this process, which is a significant change in the way that we conduct our business. And again, it's kind of fashionable to criticize insurance people, but in terms of what we do, particularly when it comes to recommending retirement types of products, that the level of complaints on our practices have been declining significantly or are almost minuscule. Is there a complaint every now and then? Yes. Do we try to resolve it amicably? Yes. And, the worst thing that we do, I always say this, the worst annuity product, and I have my opinions on that. You have your opinions on that. Rob certainly has his opinions. He's got a well-trained staff that always brings you the best and brightest in terms of product and design every day. But the worst, or whatever the worst is, the worst fixed index annuity didn't lose a dime in the meltdown of 2008. Didn't lose a penny. That's a great testament to what we have to offer. So all these things are arguments that are being made in the court system. So who are the big players here? Well, the one that we participate in is NAFA, the National Association for Fixed Annuities. I'm telling you right now, Rob, I'm coming out in a different way. National Western Life contributed significant funding for the lawsuit for NAFA. Other carriers did too, and I'm going to ask you to take a specific action in a little bit relative to that. The AACLI, the American Council of Life Insurance, the IALC, the Indexed Annuity Leadership Council, that's a group comprised of some other carriers. I'm going to name them. American Equity, Life of the Southwest, North American, otherwise known as Nicola and Midland. They have filed suit. And MSG, that is another organization that's done that. In addition, all combined in another lawsuit, here's a potpourri of organizations: Chamber of Commerce, Financial Services Roundtable, Insured Retirement Institute, Securities Industry and Financial Markets Association, Texas Association of Business, and the Greater Irving, Las Colinas, Lake Houston, and Lubbock Chambers of Commerce. Thank you. Visit beautiful Lubbock, home, birthplace of Buddy Holly. So there's a variety of different organizations in play suing the Department of Labor using those various arguments for seeking some type of relief, an injunction, an overrule, something to give us some way to make and work with this regulation. Now, I'm going to pause. Everything that I've given you is verifiable. I've done the research. By the way, I read all 1,300 pages of the DOL regulation. So I've done immense research on this. I've been to Washington, D.C. I've talked to the regulators. I've talked to the legislators. I've talked to industry leaders. So everything that I've just shared with you is fact. Now, I'm going to pause for a second for the sake of my company. Everything from this point forward is my opinion. It does not necessarily reflect the opinion of National Western Life or Rob's organization, so just keep that in mind. But, I have a high opinion of my opinion, so let's talk about that. So what do you need to do today? What can you do? Pray. That's always pretty good. Participate. That's something you can do. And prepare. So the 3 Ps: pray, participate, and prepare. Well, we know all about prayer, and I'll let you to your own conscience and your own devices. Can't hurt. And at minimum, take a moment of silence, because your business may be gone. Now, participate. There's a bunch of ways to participate. I applaud you right now because you're on the vanguard of trying to get informed on this issue. There's an organization out there that I participate in, that Rob participates in. It's called NAFA. It's the National Association of Fixed Annuities. And they are fighting for your right and for the consumer's right to have these great, safe, and certain products. I encourage you to join. I don't encourage you, look at this guy on the left. Don't put your head in the sand, because guess which part of your body is exposed. And man, you're just going to get a kick in the pants if you choose just to say, oh, it's going to be okay. I'll just wait. They'll just tell me what to do. Do something. Join NAFA. Join your local organization of NAIFA, N-A-I-F-A. Join something and try to get your voice heard. So that's the first thing. And like I said, we were just up in Washington, D.C. this past week talking to legislators, meeting with fellow other carriers. It's the one place where we get together and try to see what's going on, get updated on things, and did the best we can. I could tell you from the legislative standpoint, there is not going to be any relief there. That this is the Department of Labor, President Obama's secretary, Secretary Perez, appointed. There was a resolution to overturn the regulation passed by both houses, the House of Representatives and the Senate, and that was vetoed. So there is no legislative relief in sight for this. So our source of relief will be the courts. And as I said earlier, 5 suits have been funded. But I still think it makes sense to join an organization. Now, the final component. You started the process. You're getting informed. But now I ask you to prepare. And again, this is my opinion. I would, if I were you, I would quiz your carriers. Who's your favorite company? I declared myself, National Western Life has contributed funds. Other companies have contributed funds. I named some other carriers that are in a consortium that has filed a lawsuit. Quiz your carriers. Are you in the fight or on the sidelines? You know, when I went to Washington, D.C., they gave us a little pin. It had DOL, and it had a red slash through it, right? Like the Ghostbusters, right? Are they wearing the pin either philosophically or practically? And I want to be very clear on this, because those of you may remember we had a similar issue with 151A, an effort to categorize fixed index annuities, one of the greatest products known to the American consumer, providing safety, certainty, and upside potential. We had a regulation that was going to make that a security and difficult to sell. Carriers like National Western Life and American Equity, F&G, I think they were Old Mutual at the time, they stepped up, put money in the game. Some carriers were on the sideline, even some carriers that are in the top 10 of annuity providers. So I'm going to ask you, quiz your carriers. Are you in the fight or on the sidelines? It's very simple. And I would boil it down to this question. Have you made a contribution to any of the lawsuits against the DOL? Simple. Yes or no? Yes? There you go. They're the good guys. No, they go, no, well, we're employing optics and metrics and determining, we have a way that we're looking with the, you know what I'm going to say? I'm going to, you guys are from the Midwest. F that. F that. You're either in it or you're not. You either put money in the game or you didn't. Don't be on the sidelines. And if I were you, I would not do business with a carrier that is not proactive in fighting this regulation. National Western Life is. Other carriers are. I applaud them. You should applaud them, but you should not reward those carriers that don't support your way of doing business. You're going to go, Paul, well, why wouldn't they? Wouldn't everybody do that? Listen, not every carrier is focused on independent agents. Not every carrier wants to see this regulation overturned. You might go, well, why is that? Well, many carriers are in the securities part, the institution part, and they figure if you go away, they're going to get the business anyway just through one of their other channels. I'm going to say this. National Western Life has one channel only, and that is independent financial professionals working with great organizations like Great Plains there. Review your record keeping. Do you know that the standard expected is 6 years of detailed record. Why did you recommend this product 6 years ago? I'd also encourage you to put your practice in perspective. How do you do your business? How much qualified business do you do? If commissions changed, how would that affect your business? If we went from an average of 5.5 to 6% commission, and we went to a 1% tiered commission, or 3% with a 1% trail for 3 years, how would that affect your business practices? Could you survive? So, build your bankroll. Right now, I think is the greatest opportunity to be selling, to be promoting, to be encouraging, to be a mensch, whatever it is, to help your clients save now, protect now. Get busy. Also, consider your carrier. Do you know what they have? Do you know what they offer? Know that. Know what you need to know. This is the first step to do that. And then ultimately, learn to love life. I think that this is something that, regardless of whether we had this regulation or not, and an example of what Rob and his team there do, they provide great products, great plans, annuity, and life, great outlets. I would encourage you to build your life business as well, just because it makes sense, just because not only do we need to provide protection for our clients' assets, distribution in the form of these great guaranteed income riders and withdrawal benefit riders and annuitization, but also preservation and transfer to the next generation. And you can do that with Rob and his team at Great Plains Annuity and Life. Thank you so much for sharing these few moments with us. Hopefully I've given you some food for thought, but please, whatever you do, take some action. Certainly pray, but I want you to participate and, most importantly, prepare for what may come ahead. Rob, back to you.
Thank you so much, Paul. We've got a couple of questions. I want to go quickly here. First question, do you think that the SEC rules will override these regs? Looking at the other side of the financial institution's house, Paul, and on the security side, I think that's where this question's going.
Right. Yeah, so that's an irony that there's actually some conflict with other regulatory agencies. The SEC has been trying to work on some uniform standard, and even we in the industry, Rob, you would agree, we don't mind looking out for our clients' best interests. We think we do a pretty good job of that now. We're just looking for a standard and a process that's workable, and hopefully I've demonstrated that the current proposal, not proposal, but regulation is not workable. So, some of us look to the SEC maybe as a life raft to provide a alternative, a face-saving alternative, where all parties can say, hey, look, we got this fiduciary standard in place. Everybody's happy or reasonably happy with it, and so that's what we're going to do. So there's a possibility that might help, but the SEC has not always been the best friend to fixed index annuities either. So what is it? The enemy of my enemy is my friend. Well, that may be what's applying here in this circumstance, but it's not the absolute Band-Aid that we may want. What other questions do you have?
I think this is going to be a quick one for you. How does the best interest fiduciary standard differ from the current suitability standard?
There's a huge difference. There's a huge difference. So, best interest, basically best. Now, what a prudent person would determine, now, define that, but a prudent person would determine as in the best interest for the client. What that also opens up is the issue of 1 year from now. Well, this is different now. Why didn't you recommend that? So there's a lot of Monday morning quarterbacking associated with the best interest. The suitability standard is any type of solution, not necessarily objectively the best solution, but a suitable solution, something that gets the job done for the client. So there's a big difference. The difference maybe less than philosophically, because I know a lot of you that when you're looking at recommending something that is suitable, you're trying to do the best job possible. But the legal standard of what's suitable versus what's in the best interest of the client is a huge, huge gap, and implies a lot more liability and responsibility when you're looking at a best interest standard versus a suitability standard.
Okay, and Paul, let me tee this up to you to give you, just addressing your answer. I've got a question here asking if certain companies participated, or did you list everybody that you're aware of that donated to the legal efforts and to combating this ruling? If I was to mention 4 or 5 other carriers, might they be on the list?
The answer is yes, and that's why I say quiz your carrier, ask your carrier. I can only, not everybody is quite as bold as me, Rob, as you know, and they don't go, hey, I'm in. It's a matter of public record on the Coalition for Fixed Index Annuities, or the Council of Leadership. They don't have a name, but so those 4 carriers are American Equity, Life of the Southwest, North American, and Midland. They're kind of sister companies, as many of you know. Mm-hmm. So those companies are on record. I'm on record of declaring that. I know that there are a number of other carriers that have contributed to the NAFA effort. So I'm not going to take responsibility for naming them all, because that's not a matter of public record. But a lot of carriers have stepped up. I will also say that some carriers, name brand carriers, have not. They've not, and they may say, well, we're doing this and that, and I'm just giving you my standard, and you may differ with me and say, well, they're paying for a lobbyist, or they're, they took a senator to dinner, or whatever they're doing. My standard of whether you're in the game is, did you contribute to a legal effort to this lawsuit? I do know that F&G Life, they're in. Global Atlantic, the Forethought, they're in. But I don't want to say, I don't want to say somebody's in or out. I can, that's their responsibility. But yeah, my list was not all inclusive. So understand that.
All right, got 2 more questions here, and then we're going to wrap up. In your crystal ball, and especially being down in the great state of Texas, where 2 of these suits, I believe, are filed, when do you think we will learn, what's your crystal ball telling you when we might have an injunction or a ruling on any of the 5 suits on our side of the fence? Yeah,
I actually met with the lead attorney on the NAFA lawsuit in D.C., and their hope is to get the case in process in late October, early fall, and ideally have some disposition by late fall, certainly before the end of the year. Now that starts to cut it close, because that starts to get to 2017, but that's the timeline. I think my crystal ball is that we'll have some sense of where we're going to stand by the end of the year. So, don't wait. I don't know what the outcome is going to be. And one of those possible outcomes is that the Department of Labor might, modify something. It's a regulation. They could change it if they want. And I point towards the Affordable Care Act, otherwise known as Obamacare. And I won't get into politics, anything, and all this, but as you know, that law and the regulations associated with that law evolved even after the law was passed. This is a regulation, so there's even more leeway in terms of the implementation and the requirements. So it's quite possible, in light of the strong industry opposition and really the conflict with some other regulatory organizations like the SEC, that the Department of Labor might make some modification, ideally that is more workable. The big the big issue for us all is this fiduciary contract and the institutional oversight of independent activity. That's where the big challenge is. The second layer is this private action enforcement mechanism where basically the Department of Labor is saying, hey, lawyers, go sue these guys that are trying to help people. Those are the two big points of contention, and ideally those will get overturned completely or modified to the point where we can actually work and do our good work as we try to do it each and every day.
Okay. One last question, and I'll have no editorial comment here. Let me just hit you with this. You talked about companies not fighting against these regs. Who are the winners with these regulations?
Well, anybody with controlled distribution, I think, is people. One big winner that is seen in this area is the so-called robo-advisor, where people go online and they fill out a profile, and then there's a pie chart that comes back that says, okay, you should be in this or that. That ironically, some see the big institutions as winners in this because they can use the technology and infrastructure to say, look, we have this questionnaire and we have this and we have this optimum profile. I can tell you the loser is the unaffiliated insurance-only agent. I think that's going to, that's the one that is the biggest challenge. And even, fee-only advisors, other types of people that don't have the infrastructure to maintain these records. So, so a lot of people say, well, I'll get my Series 65 and I'll be okay. It's like, that's no antidote to this regulation. Now, I also tell people, hey, if you want to get and offer a platform, an investment platform, and that's something you want to do, well, go ahead and do that. But that is not necessarily protection from the contractual enforcement and the third-party action component of that. In fact, it might even expose you even more because you have other things that you could have offered other than an annuity. So keep that in mind, that being able to do more means that you have more to worry about. So that's my counsel there.
Okay. Paul, thank you so much. I hope and pray that we're going to have an opportunity to invite you back before the end of the year with good news and an update of where things stand at that point in time. I would really hope and pray we'd have a judge place an injunction in this. And just as you pointed out on 151A0550, the litigation and length of that, we all remember from those days that this thing would get some brakes on it and some real evaluation of the true costs and implementation would come to pass. But I thank you for today, the information you've shared. I want to echo what Paul said. I encourage everybody. We have up there, and I still think there's a value in hammering your congressional delegation in your home state to make them aware of how unhappy you were that it wasn't a 2/3 vote, or that we have the ability maybe to override that veto. But that said, this is something you need to get involved with. So looking at the industry organizations like the National Association of Fixed Annuities, I don't know what could be more critical to you if you are active in the fixed and fixed indexed annuity market than preserving your business model and your livelihood. So thank you for joining us today. We're going to attempt to record the, hopefully we've recorded the webinar. I'll get that link out for everybody just as soon as we have it available. Mr. Garofoli, thank you, and we'll see everybody soon.
Take care, everybody.